on the national data opt-out. In this webinar, we're going to be concentrating on the role of the Caldicott Guardian and making sure that Caldicott Guardians know what they need to be doing in practices for the upholding of the national data opt-out. So we'll be covering the role of the Caldicott Guardian in general, the support that NHS Digital has got to provide for us for implementing and upholding the national data opt-out. We'll have a description of the technical solution which is going to enable this, and then we'll be talking through some worked examples just to show how it actually all pans out in practice. Through the webinar as we go along, if you do have any questions arising, please do type them in the little chat text box down in the bottom corner of your screen. We'll try and answer questions at the end of the webinar when we've been through the prepared section, just in case the question you're asking is going to be covered as we go ahead. And if there are any questions that come in that we're not able to answer, then you can just email us at the Patient Data Choices email address, and one of us will get back to you. So the previous two webinars have covered preparing the practice for the opt-out and when and where the opt-out actually applies. And I'm pleased to say that those webinars are now available on the RCGP's YouTube channel, and they'll also be embedded in the RCGP toolkit if you want to recap those. And today we will be covering the upholding and the role of the Caldicott Guardian. So just to introduce our panel, I'm Geoff Schrecker. I'm the RCGP's clinical champion for patient data choices. On my left here, I've got Chris Bunch, who is the chair of the UK Caldicott Guardian Council. And on my right, I've got Paul Arrowsmith, who's the senior project manager in charge of delivering the technical solution with NHS Digital. Hello. So first of all, I'm going to pass over to Chris to describe to us what the role of the Caldicott Guardian is in practice.
Hello. There we go. Caldicott Guardians have been around for just about 20 years now, and they grew out of a report that Dame Fiona Caldicott's committee produced in 1997 when she called upon the service to appoint a senior person, preferably a health professional, should be nominated in each health organisation to act as a guardian responsible for safeguarding the confidentiality of patient information. We think that there are several thousand Caldicott Guardians now. There are a lot of organisations in the health service, and every health service organisation should have a Caldicott Guardian. And the role really is, it's a senior role within the organisation, and it's sometimes described as the conscience of the organisation as far as patient data is concerned. But it's really to ensure that the information about patients and service users is used legally, ethically and appropriately, and the confidentiality is maintained, but also that data is shared appropriately for the care of the individual. Now, I chair the UK Caldicott Guardian Council, which is linked to the National Data Guardian Office. We aim to provide support for Caldicott Guardians and others who fulfil the same function within their organisation, although they may not necessarily be called Caldicott Guardians formally. We know that a lot of people are undertaking this role, and we're here to support anybody who needs our support. We aim to be a point of contact for Caldicott Guardians. We like to think of ourselves as a key channel for communication, advice and information, and there are various ways that we've done that. One of them is a digital forum for Caldicott Guardians, which is run by Digital Health Networks. That's proving to be quite a useful discussion ground for these topics. We promote consistent standards. We've produced a manual for Caldicott Guardians
Can you speak up a little, please?
Can I speak up? Yes, sorry. We produced a manual for Caldicott Guardians, which is available on our website, and we are here to support best practice in maintaining confidentiality and information sharing.
Lovely. With which we'll pass over to Paul, and will tell us what NHS Digital's up to.
Yes. Okay. Thanks for that, Chris. So my name is Paul Arrowsmith. I'm a senior project manager on the National Data Opt-out Programme. I focus on the technical work stream, so I'm responsible for the development of the technical solutions across National Data Opt-out. But I'm also representing the implementation work stream today, and this first couple of slides covers what support we offer for organisations for implementing the National Data Opt-out. So what we're going to cover is the requirements on the health and care workforce, and also a little bit on the comms that are available for patients and workforce themselves within organisations. So I think first of all, within implementation, we're keen to make sure that organisations ensure that information governance leads, Caldicott Guardians and data protection officers are all aware of the National Data Opt-out, and that setting service has been available since the 25th of May this year. We're also asking that organisations take a look at policy and procedures for handling inquiries about data use, and make sure that they're updated to include information on National Data Opt-out and reference the National Data Opt-out in those policy and procedure documents. And then finally on this section, to prepare and inform the workforce on data use. So make sure that those patients are aware of the policy and procedures for handling inquiries, and know how to direct patients to get further information, perhaps some handouts or through the national website, which is the NHS.uk website and the Your NHS Data Matters section of that website. Or if requested, give them the information for the telephone advice line. In terms of communications, there's a range of materials that we've made available from NHS Digital. They're all available on the website that's identified at the bottom of this slide, if you want to make a note of that, while I talk you through this with the detail on the slide. So it's key that your organisation starts to display the Your Data Matters to the NHS poster, and there's also a series of handouts available to patients, so you need to be making those available to patients now. We also need to think about any existing posters, handouts and website materials, make sure that they've been reviewed and removed if they're not appropriate anymore, or updated so that patients are guided towards the latest information available. We also ask that organisations consider using the screen text for electronic displays in reception and waiting areas. And again, examples of those screen text examples are available on that website at the bottom. And you or your organisation should also consider privacy notices and consider using the recommended standard text about the wider use of health and care data, and that information can be inserted into privacy notices. And again, that standard text and supporting guidance is available and can be found on the web page. Okay, so going to move on now and look at the technical part or the technical elements of the National Data Opt-out. So we'll look first at how the end-to-end solution works, but we will focus very much on the upholding solution, which is how we make the list of opt-outs available to organisations so that they're free then to uphold in their local data flows. Talk a little bit about a pilot that we're running from early September through to the end of November. Give you some information about that, but particularly perhaps how the pilot might work for GP practices, and then finally just looking at the next steps. So before we get into the upholding solution itself, this diagram that's up on the screen at the moment, we'll use this to talk you through the end-to-end solution around national data opt-outs. And over on the left-hand side there, it's all about empowering patients. So making sure that patients can set their opt-out. And in the top left-hand corner, we've developed a website where patients can come to that website and set their preference. They need to specify some demographic details to identify who they are, but then they can go ahead and set their preference. But it's also about empowering patients who perhaps don't have access to digital services or feel uncomfortable using them. And for those patients, we've got our NHS Digital Contact Centre, where patients can phone in and speak to our operatives, again, giving some demographic details to identify them, and then the contact centre will set the preference on the patient's behalf. I guess there's also an assisted digital option to talk about there as well. So if somebody's using the digital service, perhaps hit upon a problem with that service, then the contact centre can talk them through so the patient is still using the digital service. I think the key thing to understand, though, through all of those services available to patients, that the opt-out gets stored once and then is made available across all health and care organisations. So again, this is really about empowering patients. So no longer do patients need to go to every healthcare setting that they visited and ask for an opt-out to be set at that local level. They just set it nationally through the NHS Digital services, and it gets stored in a repository on the national spine. The key then is obviously how do we make it available, and that's what we're going to come on and discuss in the Upholding solution. Before I move on, though, I'll just stress the dates at the bottom of the screen. So I've mentioned the 25th of May already. That's the date that NHS Digital began upholding national data opt-outs, and obviously from that date, patients were able to set their preferences. The only other hard and fast date that we have within the programme is March 2020, and that's when there's an expectation that the opt-outs have been upheld across all health and adult social care organisations. Okay, so we'll move on and look at the Upholding solution. Now, in arriving at this solution, we've had to consider the needs of all organisations, so irrespective of whether those organisations have spine compliant solutions maybe, or whether they've got an HSCN connection, but also thinking about the frequency of their data flows. So obviously at the large trusts, they're disseminating data on a regular basis, possibly many times a day, right down to the smallest social care, the smallest care homes that might disseminate data very infrequently, maybe just one dissemination at the end of the financial year. And then again, thinking about the technical capability that's available at each organisation. So again, thinking about larger organisations, they might already have comprehensive IT departments and technical capability. Picking on the care homes again a little bit, they potentially haven't got any IT or very limited IT equipment available on their site. So we've tried to come up with something that works across all of those scenarios. And this is what we've come up with. It's something based on MESH. If you've come across that before, that's the Messaging Exchange for Social Care and Health. And this is a strategic solution from NHS Digital that's used readily across health and care at the moment for transferring data files between organisations and NHS Digital. And the thing about MESH is that it comes in 3 different flavours. So there's something called the MESH API, and something called the MESH client, and that will typically be used by organisations where you've got systems in play, spine compliant systems, and those systems are primarily responsible for managing your data flows. So that's aiming at the end where there's more automation, that the local organisations have got these systems in place, or they've got that technical capability to interact with those MESH solutions. The third flavour allows us to tackle organisations with less technical capability or without a HSCN connection, and that's the MESH user interface, which is a lot more manual intervention and is dependent on a user-by-user interaction. I think the other thing I would say before I just walk you through exactly how the solution works is that this solution is already in play across trusts and practices in particular. So it's used for transfer of path lab results, and it's also used for the visitors and migrant service. So it's been modelled on something that's already out there and sort of proven in live environments. So I'll just walk you through quickly how it works. It's fairly straightforward. So every time a health and care organisation has some data ready to share or disseminate on, you need to look at that data set and extract the NHS numbers that are involved in that data set. and build those NHS numbers into a file format that we'll specify when this service goes live. But the file format will be quite straightforward. It'll just be a single column file containing the NHS numbers. And the way Mesh works, it's a mailbox-based system. So you append that list of NHS numbers to the mailbox, and then Mesh constructs that into a message that gets sent over Mesh across to NHS Digital. And then at our end, the spine interface over on the right there is polling the mailbox on our side, looking for messages coming in from organisations. And every time we see a new file, we just do a simple lookup against the National Data Opt-out repository on Spine, and then send the file back to you. I think the critical thing to understand is that when you receive the file back, we'll have removed the NHS numbers where we found an opt-out on the repository. So the NHS numbers that you receive back, what we're telling you is that they're the NHS numbers that you're free to share within your data flow. Just a couple of other things to talk about within the mesh-based solution. Encryption is built in at the transport layer. What that means really, the benefit from your point of view is that there's no need to encrypt and decrypt at your end. So when you receive the file back from us, you'll see the file in the clear and you'll be able to see the NHS numbers. And I think the other thing that's key really for the people listening to this webinar is that we are already working closely with the 4 core GP system suppliers to enable their systems to become compliant with this solution. So TPP, EMIS, Vision and Microtest are all working with us to make their systems compliant. So when we talk about you needing to pick up these files and send files across to us, in the main, we think that will be handled through the GP systems, but we're keen to work through that with you and understand what that looks like from a GP practice perspective. So getting into that a little bit, how could you help us? So this is the pilot that I mentioned at the beginning. So we're already working with a series of mainly trusts, but we do have a handful of GP practices that are engaged at this level. And we're still working with our solution providers. It's probably fair to say that in the run up to 25th of May, our attention was all focused on the preference settings service for patients and making sure that we were upholding those preferences. But since then, we've been very much focused on making sure that we have this upholding solution available, and we're still on track to have that available by the end of the summer this year. So then we're looking to run the pilot service over a 3-month period, running from the beginning of September through to the end of November. And although we are working, we've got about 30 organisations across trusts and GP practices, but we are still keen to work with as many as possible. So if any of you are interested in getting involved at this stage, we'd be very keen to hear from you. Having asked for volunteers, it's probably only fair that I give you an idea of what's involved in being a pilot site. So it's split into 2 phases, and the first phase can start immediately. It's probably fair to say it's already happened in most cases. But this first phase is all about analysis, so looking at your information flows and thinking about whether the National Data Opt-out applies in your information flows, and then sending that information through to us, and we can make an assessment on whether you would be suitable for that first phase of the pilot. Once we've welcomed you into the pilot, we then move into phase 2, where we'll start probably in next month, in August. We would be working with organisations to make sure you've been configured for Mesh successfully. There'll be a little bit around local communication, as I talked about earlier, making sure that your local Caldicott Guardian and your local data managers are aware that this is coming along and they understand how to invoke the upholding solution, and then moving into a situation where you're actually upholding and applying the national opt-out against each of your information flows. The last point on this slide is quite important because I guess what we're saying here is we can be flexible with you. So if you have some information flows and for whatever business reason you feel uncomfortable with those being involved or those being included within the 3-month pilot window, we're we're aware, for instance, that within trusts, we've given them a let on surveys through to March 2019. So in trusts, we're not going to include surveys within the pilot. And again, it could be that in your organisations there are some information flows that you feel sensitive about including those from day one. So we can be flexible on that. In terms of that analysis, if you do express an interest in being involved in the pilot, what we'll do is we'll send that short pro forma, which goes through in a little bit more detail. It's just 2 or 3 pages giving you a little bit more detail about the National Data Opt-out policy, and you can use that to make that assessment about whether your information flows are in scope or not. And then we're asking people to complete this table that's on the screen now. This is just an excerpt from that table, and it's just asking you to identify each of your information flows, the purpose of the release, who receives that data flow, and probably critically, what's the legal basis, and that's where we have the hook into the National Data Opt-out policy. In terms of the pilot, it's the 4 columns on the right that inform your suitability. So, and probably from a GP practice side, the format column is key, and here we'd be looking for information that tells us whether all of your information flows are covered by the GP system, or we're particularly interested in whether or not you've got information flows that are currently seen as being outside of the GP system. And obviously we've then got to look at solutions, whether or not those flows could be brought into the scope of the GP system, or whether we need to be dealing with you directly to get the solution working for you independently of the system. And then looking at whether the NHS number is included in those data flows and how frequently you disseminate that data, and what's the typical volume involved in those releases. We are conscious that I mentioned about phase 1, the analysis work perhaps has already started, and what I was getting at there is that we're aware, obviously, that a lot of organisations have done this type of activity already as part of GDPR. So if you've already got some material based on what you did in GDPR, we're not precious about receiving information in the format outlined here in the pro forma. If you just want to add the detail to your existing spreadsheet or whatever you have from GDPR, we're quite happy to receive the analysis in that format as well. So if you are interested in, if you are wanting to express an interest in the pilot or getting involved at a later stage, please do get in touch with us. And if you can use the mailbox that's on the screen now, that would be very much appreciated. I'll just leave that on the screen for a little while, give you just a few more seconds just to give you the chance to make notes of that. I think this is going to become available online anyway, so you can look it up there. So my final slide is just some key points around next steps really, and how organisations need to go about meeting the March 2020 deadline. So I think in terms of that analysis piece, it's very much about starting to consider your data uses beyond individual care and whether you think opt-outs need to be applied. And then we're available basically to support you. So if you think you've got opt-outs, if you think you've got situations where you do need to apply opt-out, please get in touch and let us know. Or if you're not sure, again, get in touch and we should be able to help you out in terms of understanding the policy and how that applies to your specific data uses. I think if you get to the point where you do need to apply opt-outs, as I said earlier, really in the communications slide, you need to determine when they need to apply and who's responsible for managing that data use and dissemination, and making sure that they understand what the technical solution is and that they need to be thinking about implementing it within your local organisations. Okay, so that's it from me, and we'll then hand over to Geoff.
Lovely. Thanks very much, Paul. That's very helpful. So I'm now going to run through a bit of the background and go through some scenarios, which I hope will help to clarify just what we in general practice need to do to look at our business processes to see where those do involve a need to uphold the national data opt-out, and how that works in different situations, and what we might actually need to make sure that we're doing. So I'm going to talk briefly about handling patient data and issues related to GDPR, confidentiality, transparency, and then a bit about research, and then look at different specific business processes where the national data opt-out will come into play. So we are very familiar with handling patient data and have been for many years. In general practice, because we are independent businesses and independent providers, we are subject to GDPR. We are also subject to the common law duty of confidentiality. And as individual professionals, clinicians, we have a professional duty to uphold the confidentiality of our patients. I think it's important to make a slight distinction here between GDPR and the common law duty of confidentiality. As data controllers, we must, for all the data we handle, comply with GDPR, whether we're just using it ourselves or whether we're sharing it with others. GDPR permits a number of different lawful bases for processing data. And I think a lot of people think that we have to have patient consent. In fact, in healthcare, we use a different legal basis under GDPR. So consent is not the legal basis under GDPR. When we come to the common law duty of confidentiality, however, when we're sharing data, and particularly when we're sharing data which isn't for individual care, then we do have to have a basis for breaching confidence. Now, that may be explicit consent. The patient may say, sure, you can use my data for this research purpose or this planning purpose, and that's fine. But sometimes it's not practicable to get consent from all patients, and there are a number of legal ways in which you can override the common law duty of confidence without getting consent. And this is where the national data opt-out comes into play. We have a duty to ensure transparency, which basically means tell our patients what we're doing with their data. And part of our legal duty as data controllers is that we have to ensure that we implement what we tell patients we're going to do, which in this case relates to upholding the national data opt-out. So, a little bit more detail about GDPR. We are data controllers, and therefore we must handle our data in line with the General Data Protection Regulation, and in particular with its implementation through the 2018 Data Protection Act. It requires us to have a lawful basis when we're processing data. Now, this webinar does not have the time to go into the full detail of GDPR. I would very strongly suggest you go to the ICO website, the Information Commissioner's Office, the Information Governance Alliance, and specifically aimed at GPs, Bedfordshire and Hertfordshire LMC have produced a very good guide on implementing GDPR in general practice. And I would suggest that you turn to that for detailed guidance. Confidentiality is a common law duty. So whereas GDPR is implemented through statute law, the common law duty of confidentiality is built on a whole history of legal cases that have established how you have to behave to stay within the law. And it is additional to the GDPR. It's not an optional extra, it's not instead. You must consider the common law duty of confidentiality as well whenever you are sharing information with somebody else. The common law duty of confidentiality, unlike GDPR, includes the concept of implied consent. So if I see you for your gout, and then you go to see my nurse for your gout, there is an implication that the nurse will be able to view the information I collected about you, about your gout. You don't have to seek explicit consent in that situation. However, there are other situations in which you do set aside the common law duty of confidentiality. The courts, so for example, if a court order requires information for you to go and give evidence in a criminal case, for example, the duty of confidentiality is set aside. It can be set aside in the public interest. So if a patient comes in to you carrying a weapon and says he's about to go home and shoot his wife, there is a public interest that you notify the police of this, and that's a clear-cut case. Public interest is a tricky one at times, and I very much recommend that if you're considering public interest, it's well worth discussing it with either the General Medical Council's advisors or your medical defence organisation. Certainly the GMC are very helpful in that situation. There are two other situations which are important from the point of view of the national data opt-out. The first of these is the NHS Act 2006 section 251, which is a bit of a mouthful and won't be familiar to anybody who hasn't been up to their eyeballs in information governance for years. But this section allows for a request for somebody to access confidential information where seeking consent is unreasonable and there's a significant public benefit. And it applies both to research and to planning. An application goes to an independent advisory group, the Confidentiality Advisory Group, and they make a recommendation in the case of research to the Health Research Authority, and in the case of planning to the Secretary of State as to whether that use of data should be approved. If they make such a recommendation, and if that use is then approved, the practice is permitted to release data without seeking the consent of the individual, but is not mandated so to do. So, for example, the practice receives a request for audit information with a Section 251 approval. The practice may say, actually, we don't want to take part in that audit and not send the data. Under the Health and Social Care Act 2012, Section 259, NHS Digital can require a practice to submit confidential patient information. The difference here is that because it is a statutory requirement, once such a collection has been approved, the practice does not have the freedom to decline. You must supply the information. So both Section 251 and Section 259 enable an override of the common law duty of confidentiality, but whereas Section 251 permits it, Section 259 mandates it. And this difference is important when it comes to the national data opt-out, because the national data opt-out applies where the legal basis is Section 251, but does not apply where the legal basis is Section 259. Although a Type 1 objection applies to both Section 251 and Section 259 releases. So we've talked a fair bit about the national data opt-out. The detail of exactly when and where it applies is covered in our previous two webinars. So we're not going to go into great detail on that now, but point you back to those webinars which are available on the RCGP YouTube channel. But the important point is it applies with a legal basis for the dissemination of information is the NHS Act 2006 Section 251. It does not apply if the patient has given explicit consent for that collection, and it doesn't apply to the Health and Social Care Act 2012 Section 259. You will recall that I mentioned the importance of transparency as one of our duties. Whether the NDO applies or not, we have to make sure that our patients are aware that the National Data Opt-out exists and whether it will or will not apply. So one example is a collection under Section 259, which is taking place. You do have to make sure your patients are aware of it, and they have to be aware that the National Data Opt-out will not apply to that dissemination of their confidential patient information. Considering research, we need to think about the legal basis for dissemination of information for research, and the basis for overriding the common law duty of confidence will be either consent or a Section 251 recommendation and approval by the Health Research Authority, HRA. You'll see on this slide, which is taken from the Information Governance Alliance literature on legal basis, that nowhere under the GDPR legal bases is there any mention of consent. Research, which basis you use under GDPR will depend on what kind of organisation you are, but you will not be using GDPR consent as your legal basis for the processing of information for research. So I'm now just going to go through 3 different business processes where the National Data Opt-out is being applied in practices. The first one is where the data is being gathered through the General Practice Extraction Service, GPES, which is operated through the GP clinical system. The second one is where third-party suppliers are obtaining and using patient information, both for individual care and for other purposes. And the third scenario is where you've actually got a small-scale research project where somebody's actually just coming into the practice and gathering data from the GP clinical system. So in our first scenario, the GPES system is run by NHS Digital. They create the business rules to identify the patients who are going to be, whose information is going to be gathered. They put that all together and they send it to the GP clinical system. The GP system then processes that set of business rules and generates a list of NHS numbers. And this is the service that Paul showed you. The NHS numbers are sent off to the National Data Opt-out Spine Service, processed. The numbers which relate to patients with a National Data Opt-out in place are removed, and a list is sent back to the GP clinical system with NHS numbers with those who have a National Data Opt-out removed. The GP clinical system now runs the report to produce the required data on that redacted list of NHS numbers and sends it back through GPES to be disseminated to whoever is going to be using that information. So that's a nice straightforward process. What does the practice need to do? The practice is still the data controller. All of these flows are data processors. So in this case, the GP system supplier is acting as a data processor on behalf of the data controller. The data controller must have a contractual relationship with the data processor, which ensures that they will comply with all appropriate data legislation. Since GP SOC and Connecting for Health, the GP system suppliers' contracts are actually with the CCG, they are not with the practice. However, there is a data processing deed of undertaking, which has been signed by all the GP system suppliers, which provides that legal framework for all this processing to take place legitimately with the practice as data controller. The second scenario is where we actually have a third-party system which is using information, confidential patient information from the GP clinical system, but possibly for both individual and other uses. So the third party requests information from the GP clinical system, which sends it back to the third party supplier. That may, for example, be to run an appointment system. However, it may also be used for service management, planning, or other uses. In that instance, the third party, when it comes to a use for planning or research, will send the list of NHS numbers to the spine service, which again will process that against their list of NHS numbers of patients who have an opt-out in place, and return the cleansed list to the third party, who will then do their reporting or whatever other processing they're doing against that list of redacted NHS numbers. The GP practice in this instance is, of course, still the data controller, but in this case, the third party is a data processor on behalf of the data controller. It is therefore essential that as a practice, you check your contracts with that data processor to ensure that they are clear that that data processor is acting on your behalf and will fulfill all the duties, all your duties when processing that data. The contract must be very clear on that the data processor must abide by and implement the national data opt-out. The third scenario occurs quite frequently with small-scale local research projects where perhaps a local university is doing a project on a particular disease and they recruit some local practices to help them out with the research. So the research body gives the criteria for their patients to the practice. And the practice then needs to identify the list of patients who are appropriate for that piece of research. They need to make sure that those NHS numbers are sent to the National Data Opt-out Spine Service to be checked against the National Data Opt-out database. Again, they will receive that returning information from the spine service to say, well, having removed any NHS numbers for patients who have an opt-out in place, they will then pass that redacted list of NHS numbers to the researcher coming into the practice. And that researcher can then identify the important information and put that into the research project. So in this case, the practice is responsible for generating the list of patients. It may be that there will be a system through the GP clinical system supplier for uploading that NHS number list to the spine service, or it may have to be done through a different route. But the practice will need to be clear how they check that list of NHS numbers against the National Data Opt-out database. And it's important to say that only people in the practice who have a legitimate relationship of implied consent to view patients' records can deal with the program, with the project, until they've got that list, that cleansed list, back from the spine service. So hopefully that gives an overview of how the different scenarios will play out in practice. We've had some questions sent in advance, and we've got a couple of questions that have come in while we've been speaking. So we'll proceed to those, but if there are any further questions, we are still keeping an eye on the chat. Do put any further questions in through the chat box, and we will pick those up as we go along. So I think we'll come first. Philip's asked us about the scenario we were covering last, the research scenario, and perhaps if I cover that first. Yeah. And So the third-party data processor remotely accesses the clinical system to identify a subset of patients to call in for a clinical review, e.g. inhaler checks, stoma product review, then this is direct patient care. That is correct. So anything where you're going to be dealing directly with looking after the patients, that is patient care, and the national data opt-out does not apply. So if you've got somebody monitoring, as you say, stoma product reviews, inhaler checks, diabetes reviews, all of that is individual patient care and is not covered by the national data opt-out. I think Philip also asked the question a little bit earlier on about finding patients to participate in research studies. The National Data Guardian, in her report, made very clear the distinction between local audit, where data is being accessed by somebody who has a legitimate relationship with that patient on clinical grounds to access their data, and other people. And that applies also in the situation of looking for patients for a research project. In our practice, we were undertaking a research project on treatment of gout and management of gout. So we identified the patients in the practice, and those record checks were undertaken by the clinicians with responsibility for looking after the patients. So just as if you saw the patient in your clinic and were reviewing their gout and said at the same time, right, by the way, there's this research project you might be able to take part in, you don't need the patient in front of you. If you have that relationship with the patient, it's entirely reasonable to look at the records, to identify the patients, and contact them then to take part in the study. Where I think it would be more difficult would be if the person undertaking the study said, we can send somebody in to look at the records. That person does not have an established legitimate relationship to view those records. And I think it would be unwise in that situation to give access to the records. I think it needs to be done by somebody within the practice who has that existing legitimate relationship. So hopefully, Philip, that answers your questions. But if not, please get typing and add in a supplementary.
Yeah,
Chris,
I read that question as, if the patient has already registered an opt-out, should you not contact them?
No, I think if the patient, well, firstly, you won't know if the patient's registered an opt-out.
Unless you check.
Unless you check.
Yeah.
But secondly, you have to bear in mind that one of the things that overrides a national data opt-out is explicit consent.
Yes.
And if you don't identify the patients who might be eligible for the study, you can't obtain explicit consent to override the national data opt-out. So okay. I think that given the guidance by the National Data Guardian that somebody who already has a legitimate relationship with the patient's data can access it, I think you would be on a very sound ground.
Yeah, I agree.
To do that.
I agree.
Yeah.
Yeah.
Good. Just the DocMail bit. DocMail is acting as a data processor on your behalf, so long as your contract with DocMail, which I'm sure it will, is very clear about their role as a data processor, DocMail is fine. Another question here, I think this is one for you, Paul. How long will it take to receive the information back from the National Data Opt-out Spine Service?
Yeah, I mean, unfortunately, there's no definitive answer to this. What I will say is that typically we're probably looking at about a 2-minute response time to send the message out to Mesh and then receive it back. Although it really depends on processes that are in play at the local level. So on our side, we're setting the polling mechanism, so where we're looking for new files coming in to NHS Digital, we'll be monitoring that every minute. So a minute of that 2 minutes goes in that part of the process. But then obviously when you receive it back to your organisation, it's how often you're polling as well for the response coming back. But obviously that would, in GP practice world, that will generally be dictated by what we agree with the GP system suppliers. But I would say of the order of a couple of minutes.
Lovely. Thanks, Paul. And another question that we had before the webinar, which is in some ways similar to that, different type of timescales. We've been asked about timescales for providing information. We talked about the transparency and we have to inform patients, but actually in GP land we're not upholding the national data opt-out yet. So what should we be doing and when should we be telling our patients about it?
Yeah, so I think this was a nervousness around should we be communicating when the local organisation isn't necessarily upholding yet. So I think it's important to split the communication into two pieces of information. So primarily around, we'd be very much wanting organisations to be proactive in terms of communicating with patients, making them aware of the opt-out and directing them to where they need to go to set their opt-outs. And obviously the same for the local workforce as well, so that they're aware of the national data opt-out. You may be aware, some of you may have seen some of the adverts that we've posted in the national press and also on a host of radio stations. So we've been very active since the 25th of May, trying to educate patients in particular that this thing is available. So anything that local organisations do or can do would be most welcome. I think alongside that, at a local level, you obviously need to be clear with your local patients that while they're being directed to go and set the preference, they need to understand that the opt-out isn't actually being upheld for that local organisation. And as obviously time progresses, you'll start to work up a plan for when that's going to happen.
Thanks, Paul. Carol's just asked us a couple of questions. Care.data, I think the important thing to say about this is that the national data opt-out will not actually have any impact should somebody try to reinstate care.data. So if you go back to the legal basis for the dissemination of data, the legal basis for the planned care.data was section 259. And as such, a national data opt-out, if somebody were to try and introduce that, if the legal basis again were section 259, the national data opt-out would not impact on that. If the type 1 objection persists beyond March 2020, then the type 1 objection does apply to section 259, and the fate of the type 1 objections is up for decision by March 2020, and a consultation with the National Data Guardian has to precede that. So yes, you need to have an open discussion with patients about the fact that a national data opt-out would not prevent their data being used for care.data. Currently, a type 1 objection would prevent their GP data being used for that, but that may not continue before March 2020, depending on the outcome of discussions with the National Data Guardian. And also, this is one initiative with GPs and NHS trusts. So the national data opt-out applies to everybody: GPs, NHS trusts, local care homes, local nursing homes, and everybody.
Pharmacies, dentists.
Pharmacies, dentists.
There's about 57,000 organisations in play.
Tom Cobley and all. I missed the word fiasco. People are sceptical. I couldn't possibly comment, as they say.
Yeah, I mean,
people are sceptical, and I think that's why I say you do need to be open with patients that care.data is a specific data dissemination, and it would depend on the legal basis, and people need to be alert to what the national data opt-out does not cover. I think that is really important.
Yeah, I think the key message is that this isn't care.data. we're not asking for information, we're actually providing a facility to stop information flow. I think that's the key.
Yeah.
Yes. Denise has, I think this relates to, so where extraction of data is taken by a clinical system and delivered to a third party for direct patient care, their data will be included. However, if the patient has opted out for research, how do organisations manage the release of patient data for the right reasons? That's the second scenario that I described. And the important thing there is that as a data controller releasing the data to that third party, it's essential that your contract with them is explicit that they must implement whatever rules there are around the processing of data for purposes other than individual care. It's essential that that is in the contract. Bear in mind, however, that the national data opt-out only applies to identifiable confidential patient information. So where the data is aggregated up and its use is therefore anonymized in line with the ICO's code of anonymization, the national data opt-out doesn't apply. Carol, yes, I think you're absolutely right. The point is there does need to be a simple but clear explanation. And I think the simple but clear explanation is if care.data comes along, a national data opt-out will not prevent your data being used.
Yeah, but it's not on the cards as far as we know
it's
at the moment.
not on the cards as far as we know at the moment. But watch this space. I think we've got time very quickly to deal with one other point that came in before us. So we've got a couple of minutes left. Relationship of opt-out to GDPR and the right to be forgotten. Chris, do you want to very briefly?
Yes, I mean this does crop up from time to time. The thing to remember is that the National Data Guardian National Data opt-out is NHS policy, and the GDPR Data Protection Act are law. It doesn't really help you to know that, but that's the case. Under the Data Protection Act GDPR, the legal basis for processing data for direct care is not consent, and the right to be forgotten under the legislation is for you to withdraw your consent, and if that is not the basis for processing, then it doesn't operate. In other words, you can't stop the data being processed in that way. You have to, and for direct care, as we said before, the National Data Guardian's opt-out doesn't operate. This is really only for secondary use. Yeah.
Thank you, Chris. I think that very neatly brings us up pretty much to our hour. I hope that people have found that useful. As I say, there is more detail on the previous webinars, which are on the YouTube channel. We also have one e-learning module already on the RCGP website with another to follow, and a toolkit which is being developed. So hopefully that tells you what you need to know to be able to proceed from here. Thank you very much.